Hello and welcome to the second episode of the Surviving Constitutional Law podcast. I'm your host, Cameron Shamsabad. I'm really excited today to be recording this episode because today we're actually going to be starting our long journey on this constitutional law podcast, covering off on some of the substantive elements of this area of law. Building off one of the key points I was discussing last week in the episode surrounding federalism, we're going to be talking about a fundamental building block of our federal system of government, which is state governments and state legislative power. Today you can expect in the podcast I'm going to be covering why exactly we have state governments and state constitutions, and I'm going to be discussing that in the context of some of the history of our country, in particular the colonial governments which arose in Australia since the settlement in 1788, and also the emergence of the Colonial Laws Validity Act, which eventually in 1865 gave the Australian colonies and their legislatures the capacity to make independent laws for themselves. After that, I'm going to be discussing federation and how these colonial governments made the step into being states under our new federal system of government. Having set out all of that history, I'm then going to move on to the nature of state constitutions, particularly by setting out the differences between state constitutions and the Commonwealth Constitution. One in particular being the plenary nature of state powers, which I'm going to discuss quite a lot in today's podcast, and I'm going to compare it with some overseas examples that we have. Given all of that, I think it's a good idea to round out the podcast with some of the limits that exist on state powers, in particular arising through the Commonwealth Constitution, and also just quickly set out why this is so important as a starting point for your constitutional law journey. While this topic is quite broad, I'm going to try and keep it brief today. So if you aren't already, sit back, relax, and let's dive into this week's constitutional law topic. So let's kick off the topic. Why do we actually have state governments? So state governments were initially founded as colonial legislatures in the time preceding federation. And following the Australian Constitution being adopted, they've actually managed to keep their identity and legal authority separate, both from the new national government as well as from each other. Since the initial settlement of New South Wales as a penitentiary in 1788, the period of colonial government began in Australia. At this very early period, things were quite different from what we recognise today. Government in the early colonial times was very much a dictatorship of the military governor who had been granted authority by the British Parliament over that particular colony. H.V. Evatt, who was the Chief Justice of New South Wales as well as Justice of the High Court of Australia, once characterised this very fundamental and foundational period of our history by stating, and I quote, "At the first stage of settlement, the governor, as the king's officer, was exercising absolute control of an unusually extended penitentiary, most of the members of which were compelled by law to remain within it, and the remainder of whom had to be regarded as choosing to remain within it. Therefore, the only legal basis of the absolute dictatorship of the governor was that he was in law regarded as the superintendent general or the head jailer of that particular colony." End quote. So the way we really should think about this from the beginning is this early development, beginning from Australia being settled by British colonists as initially a penal colony, and then inevitably growing and becoming something of a ordinary settlement as people began to choose to actually remain in Australia and live here and tend the land as you'd expect an early settlement would begin. During this period in the 18th century, our continent received the British legal system, which has continued to rule in the colonies and now in the States since that time. But I would note just quickly, parallel to this, of course, persisted the indigenous cultural laws and traditions, which even after the settlement of the English still continued within the indigenous communities and on the land at large. I'm not going to be touching on the parallel nature of this Indigenous sort of cultural laws and traditions today, because it doesn't really run well with the topic that we're covering in today's episode. However, I would just like to keep that in mind as we move forward. So going back to this period of time and the development which occurred, the military governor, who was very much a dictator at that time, began to lose some of their absolute authority within the colonies around the time of 1824, when a small council was formed and began meeting in Sydney to advise the governor on legislation he was actually competent to make within the colony. By 1823, an act which enabled this granted the Supreme Court, which was established in 1814, the power of judicial review over this colonial legislation that the governor was producing. By 1843, through a process of gradual change over around 20 years, this was expanded. So the council was expanded such that the members were largely elected rather than appointed, though there were still certain property requirements to such an election, and it was limited, of course, only to male inhabitants of the colony. In 1850, the Australian Colonies Government Act was passed by the Imperial Parliament, which expanded the number of members in New South Wales Legislative Council, as it was now called, to 54. And by 1855, a draft constitution for the New South Wales colony was approved by the Imperial Parliament, which established a bicameral legislature, which still today persists, and you can actually see in action on a sitting day. The Legislative Assembly, which was formed, which to some of you who are a little bit less engaged with politics, you might recognise it as the greenhouse or the green room, and the Legislative Council, which sat on the other side of the building, persisting from those early times, which those same people who might not recognise what I'm talking about would recognise it as the Red House or the Red Room. So these two houses of Parliament began the process of bicameral legislature government in Australia, and the process of responsible government being received from the British in the colonies of Australia. So I should note, at this point, the colonies were obviously still in a very formative period of history, though the reason this was extremely significant is because now our colonies in Australia have shifted from being ruled by a military dictator with a small council of somewhat ruling propertied elites in these very new colonies, and they've shifted direction to now being much more representative. They're in the British vein of government. They are a bicameral legislature where people are actually able to have their voices heard in a somewhat limited manner under the imperial system, of course, but still they are moving towards democracy and away from the sort of dictatorship which we actually had when we first started things. Due to the growing independence and competence of the Australian colonial legislatures, the Imperial Parliament actually passed the Colonial Laws Validity Act in 1865. And the purpose of the Act was to remove any apparent inconsistency between colonial laws and imperial legislation. This was to confirm that colonial legislation, provided it had been passed with the proper procedure, was to have full effect within the colony. Colonial legislation was, of course, limited only to the extent that it could not be in contradiction or repugnant to any act of the Parliament that contained powers which extended beyond the boundaries of the UK to include that colony. So if the UK Parliament wanted to, it could extend the laws to include the various colonies which were within its dominion, though ultimately, in the absence of such a clause or such a law, the colonial legislation was deemed to be binding upon that colony, and the UK legislation was not. Now, from 1865, the Australian colonies were therefore still bound to British statutes, which applied to them by express words or necessary intendment, though ultimately they had started to form a semblance of independence in making their own laws and governing for themselves. So it's within this period of time that it's generally accepted that New South Wales adopted British constitutional norms and the principle of Westminster responsible government within the jurisdiction. I'd like to point out that my focus on New South Wales is due to the predominance of the colony at this time and at this very formative period of history. It's not just because I live in New South Wales. Equally, you could have a look at other state governments of Australia today and see that they went through a very similar process during their colonial times. For example, Queensland, which separated from New South Wales in 1859 and by 1860 had formed its own parliament. South Australia, quite similarly, became a self-governing colony in 1856, and in 1857 it elected its own bicameral parliament. Tasmania in 1856 also achieved self-governance status in the Empire. Victoria in 1851, slightly earlier, was separated from New South Wales and formed its own bicameral legislature. And lastly, Western Australia, which was a little bit later in the game, though by 1890 was granted self-government status and similarly formed a legislature of its own. Ultimately, you can see within all of these histories, and I encourage you, if you're interested in the history of this period, go and have a look and see how these colonial legislatures were formed. It really does provide an interesting study of the way democracy in Australia has evolved. And if you're interested and take a look at it, it'll give you a really good understanding of why these many colonies, once they managed to get their legislative independence to some degree, didn't want to hand it over completely whenever they became a federation. These colonial legislatures were favourable by 1890 towards the idea of federation, and after the delegates approved a draft constitution in 1898, the Australian public approved the document, and it came into effect in 1901 after being passed by the Imperial Parliament. Since that time, the colonial governments became states within the system, and their powers and respective constitutions were preserved as they were prior to federation. This can be seen through several provisions of the Commonwealth Constitution, which specifically aims at preserving the laws and powers of the states, such as Section 106 of the Federal Constitution, which preserves state constitutions as they existed at the point in 1901. Section 107, which preserves the state parliaments and their powers, subject, of course, to the Commonwealth Constitution. And, of course, Section 108, which preserves state laws which were in effect at the time of federation. So all of this is basically showing that state governments, while they wanted to be formed into a federation, they wanted to preserve their independence. Ultimately, they're the ones that instigated this process of federation, and after that process had taken place, their status as colonies was transferred into a status of statehood within this new federal system of government. So that moves us on to state constitutions and state legislative power. Now, since federation, it should be noted that states have amended and repealed as well as reenacted their respective constitutions on a number of occasions and changed them in a number of ways. At the outset, before I get into this topic, I really should let you know that the nature of state constitutions is extremely different from that of a Commonwealth constitution. States have, for one major difference, extremely widely construed powers. They don't require subject matters to be defined in their constitution for a law to be considered as valid. Another key difference is that their constitutions are usually ordinary acts of their respective parliaments, making them largely procedural. They are not, as a legislature, founded by their state constitutions. Their constitutions are a product of their legislative power. Lastly, because of this quite unusual fact, state constitutions very rarely require voter permission to be amended. Normally, because it's procedural and because the Parliament has the authority to just change it and make it whenever they want, they very rarely give voters any kind of say in whether or not the Constitution will be amended. This basically should give you the picture that the state governments, through their very nature, are extremely different from the federal government. Largely, you can put this down to the influence that the state governments received from the United Kingdom as opposed to the United States. Now, in the United Kingdom, the Parliament, through a long historical development, is deemed to have an almost absolute sovereignty in its capacity to make and amend laws, as well as control and regulate all aspects of British society and government. This was inherited to a lesser extent by our state parliaments due to limits as arising under the Commonwealth Constitution. As such, state governments here are not considered to have parliamentary sovereignty in the same way as the UK. They're simply considered to have what is referred to as plenary power, which is, if you can imagine, just one step down from parliamentary sovereignty. More or less, if the state governments create a law and it does not conflict with the federal constitution in any significant way, the High Court, if it was to be challenged, would actually find, in most cases, that that law was valid. Because even if you don't have a subject matter power to look at, the power of state governments is so wide and they have so much authority coming from this British tradition that they are automatically presumed to have a just basis to create the law. So this notion that the states have extremely wide powers comes from, as I said, the idea in constitutional law of plenary power. In each state constitution, an empowerment provision is found, which is derived from British law and confers this plenary power onto that respective parliament. Normally these vary in their wording and their form, but usually read something like, for example, the New South Wales Constitution Act 1902 at section 5, which states, and I quote, "The legislature shall, subject to the provisions of the Commonwealth of Australia Constitution Act, have power to make laws for the peace, welfare and good government of New South Wales in all cases whatsoever." Likewise, Section 2 of the WA Constitution Act 1889 empowers the Parliament to make laws for the peace, order and good government of that state. See a slight wording difference in that comparison. Completely different from these two, of course, is the Victorian Constitution Act 1975, which under Section 7 grants the power to, quote, "make laws in and for Victoria in all cases whatsoever." Now these provisions mean that the Parliament may make laws on any subject matter, so long as it doesn't conflict with the jurisdictional boundaries of the Commonwealth, or bind a future state Parliament, such as to prevent its power from being considered plenary in nature. So while these provisions confer plenary power onto the New South Wales and state parliaments generally, there was also a suggestion raised in the 1980s that these words could also, by their nature, also be limiting, in that the outcome of a potential law could be objectively determined as a negative one, and therefore not actually for the good government of that particular state. This argument that not only did the plenary power provisions I just mentioned confer power, but they also inherently limited power, was argued in the case of Building Construction Employees and Builders Labourers Federation of New South Wales against the Minister of Industrial Relations, or the BLF case, as it's now known, in the year 1986, at number 7 of the New South Wales Law Reports, page 372. In that case, the Labourers Federation challenged a decision to deregister their union, though before their appeal was heard by the Court of Appeal, the New South Wales Parliament had already passed a new law which frustrated their chances of a successful appeal. As President Kirby of the Court of Appeal stated of this, it was, quote, "to remove doubts that had arisen in the hearing," end quote. It was challenged by the Labourers Federation that Section 5 of the New South Wales Constitution did not actually empower the New South Wales Parliament to abrogate certain fundamental rights. And this raised the question within the Court of Appeal as to whether the plenary power clause actually held an implied limitation. Chief Justice Street, in his judgment, entertained and endorsed a view that the powers of the state governments were not unlimited, unlike those of the UK Parliament. However, His Honour did not accept the submission brought by the Labourers Federation that these words were inherently a limitation on state government power. They were not, as he stated at page 387, an, quote, independent basis for invalidating legislation that was otherwise within the constitutional authority of Parliament." End quote. The Chief Justice's dicta, while not accepting a restrictive interpretation of the words, did find that there exists an independent line, however, of authority dating back to 17th century English law, which did in fact support a continuing judicial power to protect fundamental rights from encroachment. Now, if you have the time, I would encourage you to go and look at Chief Justice Street's opinion in that case, as it does provide quite a lot of good history and a different opinion on whether or not the judiciary has a role in reviewing laws of the state parliaments as to whether or not they violate fundamental rights, especially common law rights within our system. The Chief Justice's colleagues, however, did not on the court accept either a restrictive interpretation of the words or the line of authority which he gave, placing fundamental rights above legislative power. As the judgment of President Kirby on the Court of Appeal stated at page 404, quote, "The appeal to natural law and to a principle higher than parliamentary sovereignty is certainly out of line with the mainstream of current constitutional theory as applied in our courts." End quote. His Honour also stated at page 406, quote, "If the legislation is clear, and though the judge considers it to be unjust or even oppressive, it is not for him to substitute his opinion for that of the elected representatives assembled in Parliament." End quote. These perceptions, which the judges had fundamentally found in two regards, not only that the state judiciary has no role in overturning the constitutionally made legislation of state governments and state legislatures on the basis that they abrogate natural rights, but also the court found that ultimately the words conferring power in Section 5 were not limiting that power in any sense. It was not for the judiciary to go on a process of looking at the law and determining whether or not it was proportionate or whether or not it actually achieved the purpose, which was good government in that particular state. Ultimately, the court in this case, while Chief Justice Street entertains the idea that the power isn't unlimited, found that the authority of the state governments is somewhat plenary and unlimited. The suggestion of Chief Justice Street that there was any limitation on the scope of the words peace, welfare and good government was ultimately firmly rejected by the High Court as well just 2 years later in the case of Union Steamship Co. of Australia v. King, year 1988, volume 166 of the Commonwealth Law Reports at page number 1. The court stated in that case, at page 10, "Within the limits of the grant, a power to make laws for the peace, order and good government of a territory is as ample and plenary as the power possessed by the Imperial Parliament itself. That is, the words are not words of limitation. They did not confer on the courts of a colony, just as they do not confer on the courts of a state, jurisdiction to strike down legislation on the grounds that the legislation does not promote or secure the peace, order and good government of that particular state." In this case, the court found that just as UK courts cannot invalidate laws made by Parliament, which do not secure the welfare or public interests of the people, neither may state laws be susceptible to judicial review by state Supreme Courts. The issue of fundamental rights once again came up in the case of Durham Holdings in New South Wales 2001, volume 205 of the Commonwealth Law Reports at page 399. In that case, the New South Wales Parliament had enacted the Coal Acquisition Act 1981, which usurped the right of coal resources buried under certain lands within its jurisdiction to the Crown. The Act provided payments to the private owners of the land, but in 1990, this was actually capped, thereby denying the owners fair compensation going forward. While such an action would breach the just terms acquisition requirements of the Commonwealth Constitution set out in section 51(31), there is no analogous restriction on the states, As I mentioned earlier, their constitutions are largely procedural and contain no explicit rights or restrictions on their authority. And given they have plenary authority, they can, in most contexts and most senses, create laws as they wish. Durham Holdings in this case ultimately argued that the scheme was invalid because it exceeded the legislative powers of the state parliament, as it provided for the acquisition of property without any kind of fair compensation, which they argued was a fundamental right. The Court of Appeal ultimately rejected this argument, and the High Court of Australia refused special leave to appeal on the grounds that the argument, quote, would enjoy no prospects of success. The court in its findings ultimately dismissed that the New South Wales government had any duty to provide fair compensation for property or vested rights that it had annexed. Now, just thinking for yourself for a moment, I'd like you to imagine the potential implications of this finding and of this approach to doing law. Think about, for example, if your state government wanted to build a highway or take resources from under your house that you'd been living in your entire life. They could, in essence, pay you basically nothing for your property or the violation of your fundamental rights, and you would have no recourse against their actions. Because, as the High Court has ruled, ultimately this plenary power means that they can get away with doing things which violate these fundamental rights, and there is no limit on their ability to do so. Legal scholar and philosopher Geoffrey Goldsworthy has ultimately argued that the courts in Australia do not possess the power to protect fundamental and deeply rooted rights against the abuses by Parliament, meaning you are, as a citizen or as a person within the jurisdiction of Australia, really left naked to whatever the Parliament chooses to do. Now, following along from this, it should be stated that in each state there is a legislative provision to ensure that an administrative process is undertaken to compensate people for property rights violated by the government. In New South Wales, for example, this is, in most cases, done under the Land Acquisition Just Terms Compensation Act 1991. However, this act, according to our judiciary, could theoretically be amended, repealed, or replaced with legislation which provides little or no compensation, and you as a citizen would have no recourse to claim the value of your lost property. Now, one specific point of comparison which I'm going to raise here, and one that you probably won't hear about in law school, is the way that things are done in the United States. Now, given the history I stated regarding how our state governments were formed, the influence of the United States didn't really come into effect at all at that period of time because they really were the product of British and Westminster traditions completely, as opposed to our federal constitution and our federal government, which was influenced quite a lot by the United States experience. In the United States, by comparison, the system has evolved in quite a different manner. While they do have an analogous power of compulsory acquisition in the US, both on the state and the federal level, called eminent domain, the Fifth Amendment of the US Constitution does require, in part, and I quote, "Nor shall private property be taken for public use without just compensation," end quote. So in the US Constitution, there is an express right to just compensation, and there is also an express restriction on the exercise of eminent domain. It must be taken for a public use. It cannot just be taken because the government desires to have an empty lot sitting there at some point in time. In the US, it should also be noted that the metric for just compensation is, quote, fair market value. In the case of United States v. Cartwright, 411 of the United States reports at page 546, 1973, the fair market value is the price at which the property would change hands between a willing buyer and a willing seller, neither being under any compulsion to buy or sell something, and both having reasonable knowledge of relevant facts. This means that in calculating just compensation, we're not talking about, for example, just compensation in the circumstances of the government coming and forcefully taking your property. just compensation in the United States is determined as the price which would be paid if you were in a voluntary exchange with another willing buyer. That is obviously quite different from the way things are done in Australia. Consistently with that, in Lynch and the United States, 292 US 571 in the year 1934, the Supreme Court held that valid contracts of the United States are also property, and that the rights of private individuals arising out of them are also protected by the Fifth Amendment, which means that not only does the Fifth Amendment right apply to property such as, for example, your car or your house, which can be subject to eminent domain, if the government, by its interventions, affects your rights in contract, those are also subject to the Fifth Amendment and ultimately also subject to protection. This is obviously a very expansive view on these very fundamental rights of contract and things of that kind. Now, it should be noted that the Fifth Amendment did not originally apply to state governments in the United States. However, state constitutions themselves, unlike in Australia, also contained express provisions and rights to just or reasonable compensation. One example I can give you is the Massachusetts Constitution, which was drafted by John Adams in 1779 and adopted by Massachusetts in 1780, which at Article 10 sets out this right to just and reasonable compensation. Even Article 39 of that Constitution, which amends Article 10, requires that the property annexed is, quote, no more in extent than would be sufficient for such public purposes, which includes, obviously, a requirement that the land or the property taken from you is not excessive. It must be proportionate and reasonable in the context of whatever the government is attempting to carry out and accomplish. Another example from the United States which can be given is the Constitution of Virginia, which was drafted by James Madison and George Mason, which provides in Article 1, Section 11 of that Constitution, quote, that the General Assembly shall pass no law whereby private property, the right of which is fundamental, shall be damaged or taken except for public use. No private property shall be damaged or taken for public use without just compensation to the owner thereof. No more private property may be taken than necessary to achieve the stated public use. So this means that in the United States, despite the fact the Fifth Amendment did not actually apply to state governments explicitly when the country was formed, each state constitution itself had its own way of addressing the issue of government coming and taking people's property or affecting their fundamental rights. Nonetheless, the Fifth Amendment ultimately now applies to eminent domain exercised by the states as well. Following the case of Chicago, Burlington and Quincy Railroad Company against the City of Chicago, 166 US at page 226 in the year 1897, that case actually found that the Fifth Amendment applied through the incorporation doctrine under the 14th Amendment of the US Constitution. In that case, the city appropriated private land, and at the trial of the matter, the state court had awarded the owners only $1 in fair compensation for the property taken. On appeal to the Supreme Court of the United States, the very great Justice John Marshall Harlan delivered the majority judgment and stated in quite profound and strong principled terms, and I quote, "In determining what is due process of law, regard must be had to substance, not to form. The legislature may prescribe a form of procedure to be observed in the taking of private property for public use, but it is not due process of law if provision not be made for compensation. Due process of law as applied to judicial proceedings instituted for the taking of private property for public use means, therefore, such process as recognizes the right of the owner to be compensated if his property be wrested from him and transferred to the public." Continuing to quote Justice Marshall Harlan, I continue and I would state, quote, "In our opinion, a judgment of a state court, even if it be authorized by statute, whereby private property is taken for the state or under its direction for public use, without compensation made or secured to the owner, is, upon principle and authority, wanting in the due process of law." End quote. This judgment fundamentally states that the fundamental rights of the people, while subject to these legislatures in the relevant states, ultimately are protected not only by those fundamental rights set out in their state constitutions, but also under the US Constitution. That property taken and fundamental rights violated without proper due process, without compensation, is ultimately nothing but a violation. This approach that the United States took by limiting not only the federal but also the state governments is completely different to the one which we have according to our system of government and the plenary nature of state constitutional power in Australia. The system of complex rights protection in the US should be really contrasted, particularly with the nature of the Australian states and the UK Parliament. Whereas in the US there are layers of constitutional limits on the power of the states and national government, in the Westminster and English tradition, the Parliament has an almost unfettered authority and power to abuse, if it so wishes, the fundamental rights of people within its jurisdiction. The reason I'm canvassing this for you is because this is something which you don't normally get within constitutional law as it's taught in the universities, this sort of comparative analysis. Obviously, this is just focusing on the right of property, for example, but it could also be applied to your right of speech, your right of association, and all measure of other things. When it comes to the state governments in Australia, there are little or no limits on what they can actually do and how they can regulate you, due to the absence of rights not only in state constitutions, which are, as I stated, mostly just procedural, but also under the federal constitution, which has basically no rights in it anyway, and whatever really meaningful rights are currently being found by the High Court are ultimately impliedly brought into the constitutional law. They're not actually expressly stated. So on that basis, I'm just contextualizing the nature of the power in Australia is extremely different and much more unfettered. So this quite broad state power that they hold where they have competent jurisdiction should be really contrasted with some of the limitations, the very few limitations which are derived from the Commonwealth Constitution and placed upon the states. Now, these are the limitations which prevent the state governments from having the UK form of parliamentary sovereignty. These are what makes it sort of plenary power. They can be really summarised into three quite narrow categories. And as I stated, the power is quite unfettered because the Commonwealth Constitution doesn't actually limit the state governments excessively in any sort of manner. The three categories that you could really divide them into are, firstly, powers that are exclusively in the hands of the Commonwealth Parliament, which states are deemed not to be competent to make laws upon. One of those is found in Section 52, which sets out the Commonwealth's exclusive power over the Australian capital and federal territories, as well as in relation to matters of the various departments of the federal public service. Section 90 is also another exclusive power of the Commonwealth Government, which gives them exclusive authority to impose duties of customs and of excise, and to grant bounties on the production or export of goods. The second category of limitation on state powers are express limits on the authority of states. There's really two major ones that should be noted for our purposes right now. One of them is Section 114, which states that state governments cannot raise armies or navies without the consent of the Commonwealth, nor can they impose taxes on any kind of Commonwealth property. Section 115 also imposes another limit, which states that they cannot create local currencies or coin money themselves, meaning they must rely on the federal government to do this for them. Aside from these two categories, there's also a third category that's been formed, which is limitations that are implied through the federal constitution. One of these limits is the freedom of political communication, which I'm not going to dive into too much today, but definitely deserves its own podcast episode in the future, much like the other implied limitation, which is the continued institutional integrity of state courts must be upheld, as they are repositories of federal judicial jurisdiction. This is another topic which I will delve into in much more detail in the future, but for the moment, we're just going to have to put aside. Ultimately, canvassing these three categories of limitations, you can see that state governments, even through the Commonwealth Constitution, don't really get too much attention on the limitation of their authority. They really are, where their jurisdiction is competent, quite broadly empowered. With that said, I think this is a really good point for me to wrap up the episode today on. Doing a slight recap and taking a few steps back, it's been good today to cover why we have state governments as a foundational point for our system, going all the way back to the colonial history and the colonial legislatures, how they developed their own independent authority from the imperial legislature, and then also looking at how these colonial governments transferred into statehood after the process of federation was completed. With that in mind, of course, I also discussed the differences between the state constitutions and the new Commonwealth Constitution, which has been developed, and in particular the plenary nature of state legislative powers, and some of the impacts that can have upon fundamental rights of citizens, looking in particular in contrast to the United States, and how in the US the idea of protection of fundamental rights is much more important, whereas in Australia there has been a larger focus upon the preservation of power, and legislative power in particular. With that said, I also covered off on the limits which can be found, the few limits which can be found on state legislative power in the Commonwealth Constitution, and some of the impacts that can have on states and how they make laws, but ultimately the more in-depth analysis of those important limits, such as the freedom of political communication and also the independence and the integrity of the judiciary in the state governments, ultimately deserve their own podcast episodes because they are quite big topics. Lastly, I'm going to just quickly state why this is an important starting point for your constitutional law journey. Ultimately, because we have a federal system of government in Australia, knowing about state constitutions and state legislative power is extremely important in understanding the interaction that occurs between state and federal jurisdictions within this country. If you don't understand the nature of state power, you can never really contrast that or understand how that interacts with the Commonwealth legislative power. Ultimately, if you don't understand that, it's going to make understanding things like inconsistency or intergovernmental immunities down the track extremely difficult. So having a good solid framework understanding of state legislative power and state constitutional law is extremely important. And my hope is that this episode of the podcast, albeit being quite short, has actually helped you in getting a better grasp on the history and the substance of this area of constitutional law. On the next episode of the podcast, we're going to be continuing our journey regarding state constitutions and state constitutional law by discussing the concept of state constitutional amendment. Obviously, I stated a bit earlier that state constitutions can be amended by ordinary legislation passed through the state parliaments. But what if the state parliaments wanted to impose a referendum requirement? How exactly would that work? Well, we're going to be discussing that on next week's episode. So, I hope you'll join me for that. Until then, however, stay well, and I encourage you, as always, keep reading.